More from the studio on business tune-ups, right? It's 2021. Man, that Santa Claus better be out of your eyes. That New Year's better be out of your eyes. You better be done with that glass of champagne. Baby New Year, Father Time, all that. It's time to get to work. Now, business tune-ups, what are in a well-written contract? A lot of people think a well-written contract includes a mandatory binding arbitration clause. I'm not saying that's wrong, but here's my warning with that, my business tune-up warning. If you see arbitration, the alarm bells are going off. Burp, burp, burp. Why are the alarm bells going off? You're going to open up your wallet and you are going to be stroking a big check. Arbitration with the American Arbitration Association or some other entity is costly. It costs about $400 to file a lawsuit in the state of Texas. If you're a corporation, you have to hire a private lawyer. You cannot represent yourself as a corporate entity. That's fine, right? But what you are saved from paying the administration fee of that entity, that arbitration entity, and a private attorney who's going to play judge, who's going to sit as judge and make a binding ruling, a non-appealable binding ruling. It's okay if your contract contemplates arbitration. Make sure you know that's there, what that means, and what that means to your company financially. Because here's an example of where arbitration goes wrong on a handshake deal. Company A, Company B, they love each other. It's the honeymoon phase. Hey, we're going to recycle this old agreement. It worked for Fred. We did this a couple years ago. What do you say? This guy, okay, we'll just change the names. It has an arbitration clause. The contract with Fred was millions of dollars. The contract with number two over here with Sam, less than $100,000, maybe $100,000. Is that one that needs to be disputed in arbitration? You're talking about minimum $2,500 to $10,000 in administration and filing fees. If the other side can't afford arbitration and you're the complaining party, you might be required to pay the entire arbitration amount to push the whole thing through arbitration. And that can be thousands of dollars that are not contemplated. So make sure in that honeymoon phase that there's a complete understanding of all of the ramifications and hidden costs in a contract. Make sure it's well written. Make sure it's not completely one-sided. Make sure your business and your family and your finances are protected as much as possible. And look at it from time to time, right? Look at it before you're 2.5 years down the road. Wheels have come off, plane has hit the mountain, people are upset, and they're calling lawyers. You can't fix the contract at that point. It can be amended if there's problems in it as the deal is moving, but it can't be fixed once you're in the fight. So make sure you have a well-written agreement. Tune it up from time to time, just like you would get a checkup for anything else in your business. Check on your contracts, make sure they're simple, you understand them, you know where the costs are, and that when there is truly a handshake, everybody understands what they're agreeing to. If you have any other questions, chat at ashmorelawfirm.com, chat at ashmorelawfirm.com, or text Ashmore X2 to 47177, Ashmore X2 47177.